Thank you. I'm very grateful to have been invited to be with all of you this morning, and especially to me to be with so many impressive panelists and good friends. What a summer, right? Praise God, Roe versus Wade was overturned. So for those of us from the Midwest, it's a little bit like saying the Wicked Witch is dead, right? I'm going to talk about Kansas later, so there's some way in which that's apropos. But we have to remember there was more, right, than one Wicked Witch. So an important battle is won, right, but the war continues. So the Dobbs decision struck very different notes, as we all know, in our country. For those of us many of us obviously here see it as the answer to decades of prayer and to decades of strategic planning, and especially to emphasizing judicial appointments over the years, right? So to reverse a case that we all view as one of the greatest violations of human rights and on par with Dred Scott or Plessy versus Ferguson. And then, of course, in contrast, supporters of abortion rights viewed Dobbs as a really terrifying experience, and in particular, the view as an end to equality and freedom for women. And they promised a summer of rage, which thankfully mostly did not materialize. So what I'm going to cover in the next 30 plus minutes is to kind of take a step back from that heated rhetoric and to give you a primer on abortion jurisprudence, what led to up to and including Dobbs. So it's a bit technical. This is, I think, mostly a non-legal audience, so hopefully it will be helpful to everybody. Even though Roe versus Wade has been overturned, it still remains incredibly important to understand the legal concepts at play, because we now have 50 states, right? 50 battles. And the law and understanding what it is incredibly important and sadly incredibly confusing for most people. So I think it's important to kind of give a basic primer on this. I think it's also helpful for understanding the disconnect between what the law says and what public perceptions about abortion are. So there's a range of opinions, of course, in our nation about the practice of abortion and whether it ought to be legal. And so there's this range of opinions, but there's also a tremendous amount of confusion. So before Dobbs, 60% of Americans said that they didn't think Roe should be overturned. At the same time, 71% of Americans wanted some or even significant restrictions on abortion. And the amount of Americans who want restrictions on abortion increases the farther along the pregnancy goes, or conversely, the support for abortion drops dramatically the farther along the pregnancy is. So only 28% of Americans support second trimester abortions, and only 13% support third trimester abortions. So public opinion data tells us both that people supported Roe and they support abortion restrictions, some significantly so. But as I hope you will appreciate after this primer, Roe allowed for unlimited abortion throughout the entire pregnancy for any reason if a state so chooses. So in reality, there's this huge disconnect between what Roe allowed and what most Americans are in fact comfortable with. So hopefully my remarks will help you to address that confusion in your conversations with colleagues or neighbors or citizens. So let's take a step back and look at this backdrop of federal law. And for any lawyers who are out there or know this well, I apologize in advance, because any attempt to summarize 50 years of jurisprudence in 30 minutes it reminds me of this time I went to London and saw all of Shakespeare's plays performed in 1 hour or something like that. So it's going to be a bit like that. But I'm focusing on two aspects of these decisions that I hope will focus our remarks. So one is, in these cases, the nature of the right that the court articulated. And then second, that the consequence of the nature of the right is the test that the court adopted to evaluate future abortion regulations. So the nature of the right. and the test. And along the way, I will also discuss the role of stare decisis, which is the principle by which courts adhere to prior precedent. So first, the nature of the right. So in order to understand the nature of the right to abortion, I have to say a few words about something called substantive due process. So substantive due process is the notion that the protection of the 14th Amendment, and for those of you who don't carry your pocket constitution in your calculator, or next to your calculator in your pocket, the 14th Amendment provides that the government may not deprive any person of life, liberty, or property without due process of law. And substantive due process is this notion, most of us hear due process of law and probably think that it requires some kind of process, right? A procedure, like you have to be notified or you have to be given the opportunity to respond. Those kinds of procedural protections. That's what most people think of when they hear due process of law. But substantive due process is the notion that protection extends substantively and actually limits what the government can and cannot regulate through the use of its legitimate lawmaking authority. So in other words, all of the process in the world doesn't matter if the law itself is judged to be an impermissible exercise or overreach of state authority into a realm where it doesn't belong. And so typically, those areas where the state may not interfere are said to fall within the 14th Amendment's protection of liberty, right? Life, liberty, or property. So the critics of substantive due process say, well, this doesn't really make sense because those rights are not in the Constitution, right? And so judges are just making it up. This is impermissible policy making. That's one critique of the substantive due process theory. Another is even if we accept that there might be some unenumerated, non-textual rights encompassed within liberty, how do we know what they are? How do we figure out what they are? And most of the early cases involving substantive due process say that the way to figure out what those rights are is that they have to be things that are deeply rooted in our nation's history and tradition, or they have to be implicit in the concept of ordered liberty. So we might think of things like the right to marry, not mentioned in the Constitution explicitly, or parental rights, not mentioned explicitly in the Constitution, as those sorts of things, right? They're not mentioned, but nobody really disputes that they're part of a well-functioning polis. So that's a whole body of academic debate, whether there should be such a thing of substantive due process, and if there is, how do we know which rights are encompassed by it? But even if we accept there is such a thing as substantive due process and we have a test for identifying it, what does that mean? Well, a chief consequence is that any law that infringes on one of these fundamental substantive due process rights is subjected to increased scrutiny. And in legal lingo, we call this the standard of review. So if an ordinary law is challenged, a court will apply a low standard of review called rational basis. And here a court just asks, is this law rationally related to some legitimate government interest? And if it is, then it's deemed to be constitutional. And states almost always win challenges based on rational basis. It's a very low bar. But if a fundamental constitutional right is at stake, then a higher standard of review applies, called strict scrutiny. And here the court asks, in passing this law, did the state have a compelling state interest that is narrowly drawn, and the law has to be narrowly drawn to express only that compelling state interest. And states almost always lose under this very high standard. And in legal circles, the test is called strict in theory, fatal in fact, right? So back to abortion. So that's substantive due process. So how did the court articulate in Roe the right to abortion? So the right to privacy, under which abortion was originally determined to be a right, was first articulated in Griswold v. Connecticut. So in Griswold, the court struck down as unconstitutional a law criminalizing the use of contraceptives by married couples because it infringed on, quote, notions of privacy surrounding the marriage relationship. So interestingly, A little side note here, the right identified, the right to privacy, was not described in terms of liberty in the Substantive Due Process Clause that I just described, because, again, this is a whole nother tangent, but by this time in the 60s, the substantive due process theory that I just described had largely been discredited due to a reaction against its aggressive use in the economic sphere. So substantive due process was at its low point in terms of, it had largely been repudiated. So instead of describing it as liberty, instead the court in Griswold used a reasoning that has now roundly been mocked. What they said is that the Constitution, if we read it all together, all of these different provisions and amendments, creates zones of privacy that come from the emanations of the penumbras of various enumerated rights. So those of you who've heard the emanations from the penumbras language, that's where this comes from. They were avoiding using substantive due process and instead made up the emanations from the penumbras rationale. And the court said that married life was one of those realms that in history and tradition, so it's still linking to those tests of substantive due process, that married life was one of those realms that was protected from government intrusion. So it wasn't that the court said married couples had a right to contracept, which Griswold is now almost uniformly cited for that principle, but that's not what it held. It didn't say that married couples have a right to contracept. Rather, it said that marriage was a realm where the government shouldn't be interfering. And there's this passage in the decision where the court is clearly very concerned with the police entering the bedroom and searching the drawers and that sort of thing. So the court specifically indicated, for example, that laws banning the manufacture of contraception or the distribution of contraception might have been constitutionally permissible. It was just that this law related to the use of contraception by married couples. So that's really not mentioned anymore by most scholars about Griswold. But nevertheless, the dissenters in Griswold criticized this decision for importing their own social views into the Constitution, criticizing this expansive notion of finding unenumerated, non-textual rights in much the same way that the court had been doing in the economic sphere that had been repudiated. Within 7 years in Eisenstadt v. Baird, this newly articulated right to marital privacy got disconnected from marriage. And in Eisenstadt, the court articulated this right as a generalized individual right to privacy to be free from government intrusion into personal matters like whether to bear or beget a child. And there's all sorts of interesting legal history about the fact that when they wrote Eisenstadt, they already knew Roe was coming down the pike, and so they wrote it in such a way as to be prepared for that and to set the table for that. But in any case, Eisenstadt is really that hinge case because from there it was an easy leap from this individualized notion of privacy to the court's decision in Roe to find that laws restricting abortion implicated this constitutional right to privacy. Many scholars on both sides of the morality of abortion lamented the weakness of the constitutional argument in Roe. There was no effort to locate it in history and tradition or in the concept of ordered liberty, what Griswold had at least tried to do. The only way that Roe used history was to indicate the permissiveness of certain abortion restrictions, especially before quickening, in support of the conclusion that the unborn was not a person. In his dissent, Justice Rehnquist points out quite obviously that these permissive statutes, along with the ones that were restrictive of abortion, that all they demonstrated, in fact, was that states have always been free, right, to regulate abortion, that they did not support the conclusion that, in fact, there was historically support for a right to abortion. In Roe, the chief reason for including the decision to terminate a pregnancy within the right to privacy was, this is the quote, and it's really one sentence in one small paragraph in the decision. This is the extent of the argument, that the detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Now, anyone who teaches even like fifth grade writing knows that like that's a conclusory statement, and that ought to follow with, lots of arguments about why this is the case, but it's not the case. This is the whole argument for why abortion should be encompassed within privacy. In a couple of sentences, Justice Blackmun describes this apparent detriment, and he doesn't focus on pregnancy hardly at all. He makes a vague reference to harms medically diagnosable even in early pregnancy, but it's not clear whether he's talking about, harms to the pregnant mother or to conditions that might be diagnosable of the child. But he immediately, the rest of the paragraph focuses on the stigma of unwed motherhood, the distress, quote, associated with the unwanted child, and the problem of bringing a child into a family unable to care for it. So those are the reasons that abortion is necessary, because of those detriments. So Justice Blackmun concludes that the nature of the right is fundamental, and the consequence of that is that all abortion regulation will henceforth be judged by strict scrutiny, that very high level of judicial review. But the court admitted that even fundamental rights are not without exception, right? You can't yell fire in a crowded theater, despite the First Amendment. And so they set forth an additional balancing test to go along with strict scrutiny called the Trimester Framework. And basically what that did is allow the state to articulate certain more compelling interests as the pregnancy went along. So the upshot of Roe was that in the first trimester, there was no compelling interest a state could articulate at all to interfere with a woman's right to abortion. No abortion regulation in the first trimester. In the second trimester, the only compelling interest a state could articulate was an interest in the woman's health. And then it was only in the third trimester, then also linked to viability, that a state could, but was not required, to regulate and even ban abortion its compelling interest was in the potentiality of human life. But even then, it had to include exceptions for the woman's life or health. And in a separate companion case, the court defined health as so expansively as to include emotional, psychological, familial factors that really that exception sort of swallowed, right, the rule in the third trimester. So many argue that this framework was appropriate, and this was argued in Dobbs in terms of the viability framework by the Women's Health Organization and the Solicitor General, that a framework like this serves to balance competing interests, right? It's the way we weigh things that we disagree about. And so a couple of quick responses to that. First, to just be very clear about Roe and Casey that followed, it's not a true balancing, right? Because there's necessarily a finger on one side of the balance in that the state doesn't have to pursue these compelling interests the further the pregnancy goes along. It just may, right? So it's not a true balancing where one set of interests has to be given consideration now and another set of concerns has to be given weight later, right? It's not like that. It's just you may give weight to these certain interests later. Second, and this is also something Justice Alito pointed out at oral argument in Dobbs, is that those competing interests, the woman's liberty and the child's life, are really incommensurate. And so how can a balancing test ever properly resolve them? And then his further point was if they can't be resolved, that's the sort of balancing act that belongs in the legislature, right, where we can take, testimony and scientific evidence, and the legislature can weigh them. So under Roe, there were no necessary limits on abortion. So unless a state chose to enact restrictions, which would be evaluated under this very strict standard of review, abortion was permissible during the entire pregnancy for any reason. So again, pointing back to that confusion, most Americans who claim to support Roe don't realize what it actually allowed. And in the years after Roe, many, many restrictions were struck down, even things like waiting periods or informed consent laws or health and safety regulations of clinics. Remember, in the first trimester, no regulations. So many restrictions, even those that really had nothing to do with a woman's access to abortion, got struck down. So that brings us to Planned Parenthood v. Casey, which involved a Pennsylvania statute which had a lot of these restrictions like informed consent, waiting periods, that again didn't impact the woman's ultimate decision. It goes up to the Supreme Court in 1992. At this time, there were only 3 justices left on the court, left from the Roe decision. There was Justice Blackmun, who had written Roe, so we know how he's going to rule, and there was Justices Rehnquist and White, who had dissented in Roe. So we pretty much figured how they were going to rule. The court now included Stevens, Scalia, O'Connor, Kennedy, Souter, and Thomas, all Republican appointees. So many thought that the court was poised, finally, in 1992 to overturn Roe. And in history that many people are familiar with, in their private conference after oral argument, the court voted to overturn Roe. And a draft majority opinion authored by Justice Rehnquist concluded that the court was mistaken when it classified a woman's decision to terminate her pregnancy as a fundamental right, but that language would only appear in a dissent as Justice Kennedy changed his vote at the 11th hour and joined the other justices to affirm Roe. So the court in Casey, so again, thinking of the nature of the right and the test that it applied, it affirmed what it called the essential holding of Roe. It said the woman's right to terminate her pregnancy before viability is the most central principle of Roe. It is a rule of law and a component of liberty we cannot renounce. So this is one thing the court did in Casey. It stepped away from the emanation's penumbrous privacy and squarely located the right within the substantive due process liberty clause of the Constitution. So it was trying to give a firmer constitutional grounding for the right. And when it did so, it penned the famous, I'm sure most of you are familiar with, the famous Sweet Mystery of Life clause, as some like to call it, that at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. So quite terrifying concept there, but that's where it comes from, is the Casey decision. And the court went on to say that a woman's liberty in the context of pregnancy was so unique that only she could make the decision about whether to continue it. And the court goes on to say, these sacrifices have from the beginning of the human race been endured by woman with a pride that ennobles her in the eyes of others and gives to the infant a bond of love. But that cannot alone be grounds for the state to insist that she make the sacrifice. Her suffering is too intimate and personal for the state to insist upon its own vision of her role, however dominant that vision has been in the course of our history and culture. The destiny of the woman must be shaped to a large extent on her own conception of her spiritual imperatives and her place in society. So that's now the vision of liberty that the court rests the legal right on. It enunciates this, it affirms the right, but the rest of the reasoning of the court is largely based on this principle of stare decisis that I mentioned earlier, which is the principle that courts adhere to their own prior precedent. So the court, under this doctrine, will not overrule its prior decisions, even if they're wrong, without careful inquiry and analysis. And there's a whole bunch of factors that courts consider when looking at whether they should overrule prior decisions. And in Casey, the court largely rested its holding on this notion of reliance. That's one of the factors of stare decisis. Is there reliance on this prior decision in such a way that it would now be, basically a big mess to overrule it, right? And we think of reliance in the law mostly in economic terms and those kinds of contexts. But in Casey, the court said that there were 2 kinds of ways in which people had relied on Roe. One was a kind of general reliance of people in general, that we have all now organized our lives around the availability of abortion. The court said that people have organized intimate relationships and made choices that define their views of themselves and their places in society, and here's the actual reliance piece, I think, in reliance on the availability of abortion in the event that contraception should fail, right? So the court so many people want to say, well, contraception and abortion, they don't have to be linked and they don't really have anything to do with each other. But I always point them right to this place in Casey where the court actually says, yeah, this is why we need abortion in case contraception fails, right? It's a very explicit admission of the link between the two. The second kind of reliance, the court said, is that women in particular need abortion. So the court says the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. So those are the two reasons why the court, the two chief reasons why the court in Casey affirmed Roe, because of the reliance on abortion in case contraception fails and because women need it in order to flourish in society. So although it did affirm Roe, it changed it in a number of ways. First, it did away with the strict scrutiny test. So the court acknowledged that strict scrutiny had been the occasion for striking down many, many laws that in fact didn't impact the woman's final decision. So instead, they created a new abortion-specific test called Undue Burden, under which a law is invalid if its purpose or effect is to place a substantial obstacle, that is an undue burden, in the path of a woman seeking abortion. So they downgrade the test. And then the second piece is that they replace the Trimester Framework with viability. So the way the Casey test worked is that before viability, a state couldn't create any undue burden on a woman's access to abortion. But they were kind of freed up to do all sorts of things, especially in the early stages of pregnancy, that they hadn't been able to do under Roe. And then post-viability, a state could, if it chose, regulate or even ban abortion, except it had to provide exceptions for the life or health expansively defined of the mother. So it was meant as a compromise. Justice Kennedy, Justice O'Connor, they very much thought of this as a compromise. The court called for the nation to resolve its differences and to accept this national compromise and to move forward. And so, you know, we saw, right, that 30 years later, that national compromise was never achieved. And so that leads us up to Dobbs, which I will try to quickly summarize in the time I have remaining. For 30 years, Casey's undue burden test remained the governing test in this country. The court never again, until Dobbs, addressed head-on the nature of the right or the test that was applicable. All of the decisions in those 30 years considered whether a particular legislation constituted an undue burden or how the undue burden test, you know, how to define what constituted an undue burden. So all of the abortion litigation in those years was nibbling around the edges, but never squarely addressing the right or the test itself. So then came Dobbs. The issue presented to the court in Dobbs involved the constitutionality of Mississippi's Gestational Age Act, which banned all elective abortions post 15 weeks. So this, of course, presented a direct challenge to the rules of Roe and Casey, because, again, under the Casey test, a state may not prohibit or even place an undue burden on a woman's access to abortion before viability. And despite all of the amazing advances in maternal and fetal health, 15 weeks is still way before viability. So it was a direct challenge. Before the case was briefed, many of us wondered whether the state would just try to push back on the viability line, right? Point to Europe, other countries allow restrictions on abortion before viability at 12 and 15 weeks. Our abortion law should reflect this national consensus, et cetera. Others wondered whether we would just try to argue that the undue burden test should be, modified in some way. But in its brief, which I recommend people read, Mississippi hit for the fences, right? They argued that not just that the law should be upheld, but that the entire regime of Roe and Casey should be overturned. And we all know, right, that was the winning argument, that the court did not nibble around the edges. They did not just modify the test. They tore down the whole structure. So in that sense, the decision was both monumental, but also quite simple, right? So the court, in an opinion written by Justice Alito and joined by Justices Thomas, Gorsuch, Kavanaugh, and Barrett, held that the Constitution does not confer a right to abortion, that Casey and Roe are explicitly overruled, that the authority to regulate abortion is returned to the people and their elected representatives, and that henceforth abortion regulation is subject, like all other laws, only to rational basis. That's the quick and dirty summary of Dobbs. We could spend the rest of our time together unpacking the opinions. I think Dr. Crawford will do a bit of that for us. But in the interest of time, I just want to summarize a few bits that related to the primer that I've just provided, especially the nature of the right and the role of stare decisis. So, like Casey, the court did engage in a stare decisis analysis. But the court said that the first part of stare decisis analysis, whether we should adhere to a prior decision, is to ask whether that prior decision was rightly decided, something that Casey had largely sidestepped by just kind of slapping the sweet mystery of life on top of the emanations from the penumbra's language. So the Dobbs court went into a great deal of analysis to ask whether or not the right was in the Constitution, either explicitly, obviously it's not, or implicitly, whether or not history and tradition provided some evidence that there was a right to abortion, or whether the right was inherent in the concept of ordered liberty. And so the court said, applying those tests, the court said the abortion right is not rooted in history and tradition, and until the latter part of the 20th century, there was no support, not even in a law review article, in American law for a right to abortion. In a masterful takedown of the faulty history of Roe, Justice Alito devastatingly, I think, demonstrated with appendices that are very thorough, citing laws going back to the 19th century in our nation, the unbroken history that the tradition in this country was to criminalize abortion in both statute and at common law. Next, the court asks, well, even if it's not part of our history and tradition, evidently so, whether the right is somehow implicit in our concept of ordered liberty. And the court here said that our understanding of ordered liberty is a principle that sets limits and boundaries between competing interests. And in looking back over our nation's history, and especially the way in which states obviously felt free to legislate in this area, that our understanding of ordered liberty and what limits it ought to provide did not prevent legislatures from evaluating how abortion ought to be regulated, and in fact from deciding, legislating how abortion ought to be regulated. Also, the court addressed this sweet mystery of life concept, saying that if we think of if what we want to do is think of abortion as part of this broader autonomy and ability to define ourselves, the court says you're free to think about how you want to define yourself, but how you act, is quite a different thing, and defined, taken to its logical conclusion, it could license such conduct, and the court specifically mentions drug use and prostitution, right? And then finally, the court said that abortion is different from other liberty cases, and it mentions Griswold, the contraception case, and Obergefell, the same-sex marriage case. It says because abortion involves the taking of human life. So this is a unique context, the court says. One area of interest and concern for some, though, is the implications of its reasoning, even though the court took great care to say that this is different, this involves the taking of human life. Our reasoning does not implicate these other substantive due process cases. Many wonder whether, in fact, it does, right? Because this history and tradition test and the ordered liberty test are given a new vigor through the court's analysis. And so much of that reasoning, could apply to both the Griswold and the Obergefell decisions. But as I say, the court took great pains to distinguish those cases. The court then went through, having decided that the original decision was egregiously wrong, the court nevertheless went through the elements of stare decisis and said, even though it was wrong, none of the stare decisis factors justify retaining Roe. And so they went through a bunch of factors, including the reliance piece. And they say that it is not the role of the court to be the arbiter of these sort of generalized assertions of reliance. And those are properly the purview of the legislatures. So the consequence, as I said, of finding that there was no right to abortion is that henceforth any abortion regulation would be only subject to rational basis. I think, do I have a couple minutes left, or am I short on time?
Just make it brief.
Okay, I was going to make a few notes on the concurrences. Justice Roberts concurred. Many people are interested in what he concurred with the result, right? So he would have upheld the Mississippi law. However, he wrote separately to state that he thought it was unnecessary to reach the question about the nature of the right. He would not have overruled Roe and Casey. He would have just found a way to uphold the Mississippi law. And the test he recommended was that instead of asking whether the law places an undue burden, he would say, does the law provide a woman a reasonable opportunity to exercise her right? And, he, I guess, thought 15 weeks was enough time for a woman to figure out whether she wanted to have an abortion. So that's the test he would have proposed. But he concurred in the result. Justice Thomas wrote separately because he doesn't agree with the notion of substantive due process at all. And so he wrote separately just to express that view that he's already expressed in other decisions. And then Kavanaugh wrote separately to emphasize the neutrality of the Constitution on abortion. So he wanted to make very clear that this wasn't some secret grounds for a personhood argument, for example, that he just wanted to make clear that this is the Constitution is neutral. So that's Dobbs. I won't take the time to go into the dissents, but the result now, right, is that abortion is now returned to the states as it was before 1973, and states may be as restrictive or permissive as their constituencies will demand. And in some states, that means nothing will change. In states like Kansas, which we'll talk about, Colorado, New York, California, the law is already much more permissive of abortion than even Casey was. In other places, as we've seen, states have been willing to ban abortion in almost all instances. So I think Dobbs is now the occasion to bring clarity and to abortion law, but also to kind of resolve this confusion between abortion law and where Americans' attitudes are in a way that we haven't really been able to achieve before. And the promise of that, right, of that clarity and consensus is still to be realized. But I hope that will set the groundwork for the unborn child to be eventually welcomed in law from conception and protected as are all other persons under the Constitution. So, thank you.